I'm delighted to be here with you today to welcome you to the McCorkle Lecture and to welcome our distinguished speaker back to the law school. The McCorkle Lecture is given in memory of Claiborne Ross McCorkle. Claiborne McCorkle was born in 1882 and graduated from the law school with high honors in 1910. While a student here, he was a member of the Raven Society. For 2 decades after leaving the law school, he was a respected member of the Wise County Bar and was active in civic and political affairs, serving 2 terms as the Wise County Commonwealth's attorney. In 1920, in the midst of the racial violence of the Jim Crow era, McCorkle prosecuted 2 leaders of a lynch mob and secured their conviction. This was a notable prosecution and an unusual outcome at the time, and was considered a severe blow to mob violence in Southwest Virginia. McCorkle later became a legal writer and editor. He participated in the writing of the American Jurisprudence Treatise and in the American Law Reports. Claiborne McCorkle died in 1977 at the age of 94, and the McCorkle Lecture was established by members of his family to bring leading scholars and practitioners to Charlottesville to speak on areas of the law undergoing development and of general concern to the profession. Our speaker this afternoon certainly fits that bill. Pamela Karlan is a lawyer and scholar who has dedicated her career in academia, government, and the nonprofit sector to teaching about, writing about, and advocating for the constitutional rights of Americans. Professor Karlan is the Kenneth and Harl Montgomery Professor of Public Interest Law at Stanford Law School, where she also co-directs the school's Supreme Court Litigation Clinic. Pam has 3 degrees from Yale University. She received her BA with distinction in history from Yale College, and earned both her JD and her MA in history from Yale 4 years later. After law school, she clerked for Judge Abraham Sofair in the Southern District of New York and for Justice Harry Blackmun of the United States Supreme Court. A leading voice in the field of constitutional law, Pam is the author and co-author of numerous books, casebooks, articles, and book chapters, which cover everything from constitutional law writ broadly to the First Amendment, election law, the political process, religious liberty, and constitutional litigation. Before joining Stanford's law faculty in 1998, Pam served for a decade as a member of the law faculty here at UVA. Well known and still fondly remembered as a beloved colleague and excellent teacher, Pam was recognized with the All-University Outstanding Teaching Award in 1996 and the Outstanding Faculty Award from the State Council of Higher Education in Virginia in 1997. In addition to her remarkable scholarly contributions, Pam is also a gifted and industrious lawyer. She has served as assistant counsel and as cooperating attorney with the NAACP Legal Defense and Education Fund, as a commissioner on the California Fair Political Practices Commission, and as a leader in the Department of Justice's Civil Rights Division during both the Obama and Biden administrations. Pam is one of the most experienced Supreme Court and appellate advocates in practice today. She has briefed and argued countless cases before the Supreme Court and the Courts of Appeal, including Bostock versus Clayton County, the case in which the High Court held that Title VII prohibits an employer from discriminating against an individual on the basis of sexual orientation. Pam is also the co-reporter of the American Law Institute's forthcoming Restatement on Constitutional Torts, as well as a member of both ALI and the American Academy of Arts and Sciences. Perhaps Pam's Stanford colleague David Sklansky summed it up best when he told the New York Times, "If you want to know what something in the Constitution means, it's hard to think of a better person to ask." Pam, I'm so delighted that you're here with us today. Please join me in welcoming Professor Pamela Karlan back to the law school.
It is so nice to be back here. I think about UVA every day, and I really miss you all terribly. I'm not an unhappy person, but I don't think I was ever happier in my scholarly life than when I was here. Back in 1998, when I was still here, we published the first edition of our casebook on the law of democracy, and the first sentence goes like this: "The foundations of democracy are being thrown open for examination today, as they have been at only a few previous moments in political history." In particular, we observed that assumptions about democratic structures, long taken for granted in the United States, are now facing pressure along several fronts. A quarter century later, that seems even more true than it did then. The United States seems to be part of a worldwide democratic backsliding, and we can no longer take for granted longstanding features of our system, things like the peaceful transfer of power every 4 years, or the central role of a nonpartisan civil service. When I chose the title Unaccountable for my lecture today, which I did several months back, I was thinking about the word in two different senses. The definition most obviously applicable to the core of what I'm going to discuss with you today is actually the second definition that's given in the Oxford English Dictionary, where they say that unaccountable means not liable to be called to account or irresponsible. It dovetails with how Thomas Paine used the word accountability in The Rights of Man when he said that a body of men holding themselves accountable to nobody ought not to be trusted by anybody. And it was this concern that animated James Madison in Federalist 51 when he described what he called the great difficulty in framing a government which is to be administered by men as this: you must first enable the government to control the governed, and the next place oblige it to control itself. But the first definition that the OED gives for unaccountable refers to that which cannot be accounted for or explained, that is, the inexplicable. And I hope today also, at least a little bit, to tell you how we find ourselves in the position of a government in which none of the branches is accountable. Finally, by way of preface, it turns out that today is actually an oddly fit day to be talking about accountability, not just because of the present situation, but because of historical reasons as well. And I guess John Harrison will know this, but I don't know whether any of the rest of you will. Today is the 222nd anniversary of the announcement of the court's decision in Marbury against Madison, which is the Supreme Court asserting its power to hold Congress accountable by saying that it's not going to adjudicate a mandamus petition that is pursuant to a statute that's unconstitutional. And I bet even John is not going to know the answer to the second one, which is today is also the 187th anniversary of the 1868 impeachment of Andrew Johnson, a man who in 1866 gave an impromptu speech on Washington's birthday where he equated the congressional architects of Reconstruction with the Confederates. Turns out there were bad people on both sides. And in my colleague Richard White's description, referred to himself 210 times in a speech of little more than an hour, or 3 times every hour. Does that remind us of any other presidents? That impeachment, like all impeachments since, failed to remove the president from office. Impeachment is now, I think it's fair to say, a dead letter when it comes to holding presidents accountable. With respect to each of the branches of the federal government, there are 2 related questions of accountability. First, to whom or to what is the branch supposed to be accountable? And is it being accountable in that way? And second, how well is that branch holding the other branches of the government accountable? And my conclusion, it's probably not going to surprise you, is that we're in the midst of a crisis of accountability or unaccountability. So let's start where the Constitution does with Article 1 in Congress. Like all other legislators and executive and judicial officers, the members of Congress have to take an oath to support the Constitution. And that oath signals one kind of accountability, an accountability that really should be primary. But for the most part, members of Congress leave serious consideration of whether what they're doing is constitutional or not to other people, and they think more about their policy preferences or their re-election prospects. For example, my colleague David Sklansky observed that when it comes to immigration-related legislation, politicians are prepared to support the bills they know or they strongly suspect are going to be unconstitutional, leaving decisions about that really to the courts. And the same has happened with regard to terrorism-related legislation. And here's an especially depressing example. Senator Arlen Specter of Pennsylvania voted for the Military Commissions Act of 2006, which sharply limited the rights of Guantanamo detainees, and then he turned around and filed an amicus brief with the Supreme Court, arguing that the court should strike the statute down as, in his words, anathema to fundamental liberties. Now, Congress, as a branch, should also, of course, be accountable to the people. And that's another way in which I think it's fair to say Congress is falling far short. With respect to the House of Representatives, which was originally the organ of government expected to be most accountable to the people, gerrymandering and safe districting is endemic. And these policies and these practices reflect and exacerbate what I think of as a profound shift in the electorate in the United States. Over the past few decades, the American people has undergone what Bill Bishop called a big sort and what Alan Abramowitz called a great alignment. The big sort is a description of how people are more and more moving to communities in which they share a number of important characteristics, that people are sorting themselves across the country in ways that really create pockets in which everybody thinks alike and everybody shares a lot of characteristics in a way that just wasn't true in the past. And the Great Alignment refers to the way in which all of these different aspects of people's identities are fusing together to align, as opposed to being cross-cutting. And various important aspects are creating this kind of mega identity that's really identified with partisanship in a very important way. The two parties each identify with one of these two mega identities, and the public perception in the United States is that the parties are ideologically further apart than respondents in any other country in the world believe their parties to be. The public thinks of these divisions as existential. And here's my favorite statistic about that. In both 1960 and in 2010, there was a national public opinion poll that asked people whether they would be displeased if their child married a member of the other political party. In 1960, 5% of Republicans and 4% of Democrats said they would be upset. In 2010, 38% of each group said they would be upset. And that seems to be more people disapprove of their child marrying somebody of the other party than right now disapprove of their child marrying somebody of the same sex. And if it's somebody of the same sex and another party, I don't know how they deal with the contradiction. But the upshot of the big sort and the Great Alignment is that we have an ever-increasing number of safe seats in the House of Representatives that are held by hyper-partisans, in part because the nomination process is skewed towards the most partisan members of Congress. So let's turn now to the Senate. The Senate has a separate set of accountability problems. In its path-marking decision in Reynolds against Sims, the Supreme Court offered a proposition about what makes for a fair and effective representation in a government. And they said, in a society ostensibly grounded on representative government, it would seem reasonable that a majority of the people of a state could elect a majority of that state's legislators. The problem the court saw at the time was that in nearly every American state, that proposition was untrue. So just to give you the example from Virginia, 40% of the Commonwealth's population could elect a majority of both houses of the Virginia legislature. So in Shenandoah County, they had a population of about 21,000 people at the time. They got one seat in the House of Delegates. And Fairfax County, which had 13 times as many people in it, got 3 seats. And you can see that the effects of this malapportionment were going to bias substantive decision-making about many of the most pressing issues of the day. At the time, much of the court's workload, particularly in the area of civil rights, was an indirect consequence of malapportionment. Now, if we generalize the Supreme Court's point, we might posit that in a nation where federal power is ostensibly grounded in representative government, it seemed reasonable that a majority of the people of the nation could elect a majority of the Senate. Well, they can't. And the big sort and the demographic change along with it means that by the time students who are now in law school are my age, which Dick and I were discussing this earlier, is not as old. I mean, we look older than we are. Or no, we look younger, we are older than we look, but we can't remember which it is. But by the time the students who are our age, which is ancient, 70% of Americans are going to live in the 15 most populous states in the country, leaving only 30% of Americans in the remaining 35 states. Put another way, 1/3 of the country is going to elect a majority of the Senate. They're going to elect 2/3 of the Senate. And that mismatch is already underway. Now, how does this map on to the hyper-partisanship and the problems with accountability? Well, One of the ways is that the nature of the Senate itself is changing as a body. So following the ratification of the 17th Amendment in 1914, senators have been elected by the people rather than appointed by the state legislatures. And for most of that time, a substantial number of states had split senatorial delegations. That is, they had a Democrat and a Republican in the Senate. It oscillated between about 15 and 20 states for many, many years. And then starting in the 1970s, there were never fewer than 20 states that had split delegations up until 1994. So most states had senators who were accountable to the policy preferences of people in both parties. That's no longer true. Today, of the 50 states, 47 are represented in the US Senate by 2 senators from the same political party, or senators who caucus with the same political party, if you think about Angus King and you think about Bernie Sanders. And that's a figure we have not seen since popular election of Senate began. And with the big sort and the big sort and the big shift and the great sort, you see why I worry about my age. But while you think about this, in those 47 states that are represented by one party or the other, the Democrats represent 169 million people, and the Republicans represent only 141 million people. Yet Republicans hold 50 of the seats from those states, with Democrats holding only 44, the other 6 seats being split evenly between the parties. Now, some of the contemporary bias in the Senate is the product of what we can think of as meta-gerrymandering. Gerrymandering that's so baked into our Constitution that we don't even think about it anymore, because we tend to think of the map of the United States as fixed beyond politics, except for the forthcoming Gulf of Mexico, Gulf of America, Mount McKinley, Denali, and the like. But the states that we have, and therefore the kind of representative structure we have and the accountability that we have, is actually the product of a series of highly partisan and deeply debatable decisions about the admissibility or non-admissibility of new states. During the Civil War and Reconstruction, Republicans in Congress were concerned that they were going to lose control of the national government once the southern states came back into the Union. So they pushed through the admission of 4 new states that were safely Republican. Most strikingly, in 1864, Congress granted statehood to Republican Nevada, despite the fact that Nevada at that point had fewer than half the number of people that Oregon, which was then the least populous state, had. And thus it didn't meet the norm that had traditionally been in place, which was that you didn't admit a new state till it was at least as populous as the least populous existing state. At the same time that they gave statehood to Nevada, they denied statehood to Utah, which then was far more populous than Nevada, but that was then dominated by the Democratic Party. And actually, because of the combination of not having gambling until the 20th century and not having air conditioning until the 20th century, Nevada only reached a population at which it should have been eligible to become a state in 1970. Now, after the Civil War ended, the Republicans continued using statehood politics to secure their hold on the presidency and on the Senate. In 1889, I feel really bad about saying this because Liz is here, but in 1899, Congress split the Dakota Territory and admitted North Dakota, South Dakota, and Washington, each of them with very few people. And I think the last 3 people living in North Dakota are going to all be in Congress at some point because they've got 3 seats there. And 2 of those states are dramatically underpopulated to this day. But although they admitted those states, it took another quarter century to get New Mexico admitted because Republicans wondered whether a jurisdiction where most of the people were Hispanic and Catholic was even capable of self-government. Overall, of the 11 states that were admitted between 1861 and 1890, and I'm not counting West Virginia here because it was really just carved out of Virginia, 5 of them had populations that were smaller than any existing congressional district. And Wyoming has never reached the size of an average congressional district. And today, we can be sure, if you want to think about the opposite side of this, that despite President Trump's musings, there's no way that a Republican Congress is going to make Canada the 51st state, or the 51st through 61st, if each province gets to be a state, given the likely politics, nor are we likely to see at any time soon that either the District of Columbia or Puerto Rico, each of which is more populous than our least populous states, and Puerto Rico, I think, is more populous than about 20 states. They're not going to become states either. So Congress not so accountable to the people. But how has Congress fared at enforcing accountability by other government actors? Also not well here. Congress has a suite of accountability practices, ranging from the power of the purse to the advise and consent function to oversight to impeachment. And in their 2006 article, Separation of Parties, Not Powers, Darrell Levinson and Richard Pildes point out that Congress seems to use its checking power only when the party of the president and the party of Congress differ. The checks and balances really start to disappear when there's one-party control of the two political branches. We're seeing a heightened example of that today. For example, there's a statute that requires the president to give 30 days notice to Congress and provide substantive rationales, including detailed and case-specific reasons, before he removes an inspector general. The inspectors general are the officers of the federal government who are statutorily supposed to be responsible for investigating waste, corruption, and mismanagement. And yet, when President Trump fired a slew of inspectors general without complying with the law and the congressional notice, Congress did nothing except send a letter saying, we're sorry you did this, and we look forward to working with you on the new nominees. During the campaign, candidate Trump announced his intention to impound federal funds, thereby arrogating Congress's power over the purse. When his nominee to head the powerful Office of Management and Budget, the ironically named Russell Vought, testified under oath that the president ran on a notion that the Impeachment Control Act is unconstitutional, I agree with that, crickets. While Republicans voted unanimously to confirm a man who doesn't think that their control over the purse matters. When President Trump nominated a series of cabinet-level officials who are mind-bogglingly unqualified for their positions, the party marched in virtual lockstep to confirm them. This lockstep is in part a product of the president's possession of a credible threat to primary them out of office, itself a consequence both of the polarization I've already described and a campaign finance system that pressures legislators to be more accountable to out-of-district big political spenders. If you wonder about this at all, you should read my friend Jane Mayer's Polk Award-winning piece on the pressure put on Senator Joni Ernst to confirm Pete Hegseth for the Department of Defense. And of course, in 2021, we learned that the Senate is almost structurally incapable of voting to convict a president and remove him from office unless the opposing party controls a supermajority of the seats. So let's turn now to Article 2 and the presidency. What are the methods for holding a president accountable? Well, first, as with Congress, there's his constitutional oath. But that matters only to a president who takes the oath seriously. Article 2 vests the executive power of the United States in the present, the legislative and judicial powers having been vested elsewhere, and requires him to take care that the laws be faithfully executed. But we now have a president who in his first term declared that, quote, I have an Article 2 where I have the right to do whatever I want as president, and who last week announced, parroting that great constitutional theorist Rod Steiger in his role as Napoleon in Waterloo, he who saves his country does not violate any law. Laissez les good temps rouler. The current administration is pushing the boundaries of accountability. Let me focus on one example that captures a number of features of this. The president has created a new entity, the so-called Department of Government Efficiency, named in a juvenile move after a meme coin by people who are too ignorant of history to think that naming a department Doge might remind us of a Venetian republic that ultimately crumbled and disappeared. This new entity was ostensibly created to combat waste, fraud, and abuse. Almost immediately, he turned this entity over to a private citizen and his brominions who've been nominally hired as temporary special government employees. But as I earlier alluded to, Congress and prior presidents had already created a host of mechanisms for dealing with waste, fraud, and abuse. Consider the Office of Inspectors General again. By law, the Inspectors General are nonpartisan officials, and the IG Act requires they be appointed without regard to political affiliation and solely on the basis of, and I'm going to read these to you because you should be kind of clicking off like which ones does Doge qualify for, on the basis of integrity and demonstrated ability in accounting, auditing, financial analysis, law, management analysis, public administration, or investigations. And these are the people who conduct audits, inspections, evaluations, and agency program reviews of various kinds. And they report on these activities to Congress as well as to the President. For example, in the most recent semi-annual report to Congress from the Department of Justice, the OIG there describes how that one office issued 44 reports, 190 recommendations, identified several $1 million in questionable costs, and obtained around $27 million in recoveries of overspending and questionable costs. 31 convictions or pleas, and 62 terminations or disciplinary actions by government employees. Now, as I mentioned before, the IG Act currently provides that presidents can remove inspectors general at will, but before doing so, they have to follow the specified procedure that I talked about a few minutes ago. Notify Congress 30 days before you terminate the person. Now, if the president had followed this, all of these people would be gone by now, and there'd be no litigation. But instead, he fired a series of inspectors general without complying with the statutory procedure. Now, in one light, as I said, the failure to do this is puzzling because he could have just followed the procedure and those people would all be gone now and you wouldn't have people from federal programs litigating in court over whether there should be an injunction against the president for not following the law. But in another way, I think this failure is really quite telling. The president is taking the position that he can simply disregard laws he doesn't like and that he doesn't need to provide any notice to Congress of his plans while he works to substitute an entirely unaccountable new entity for a longstanding statutory mechanism. It's hard to escape the conclusion that the president wants to replace an accountable mechanism for addressing waste, fraud, and abuse with an unaccountable mechanism. Now, following the purge of the initial inspectors, the president then fired the head of the Office of Government Ethics, which polices high-ranking officials suspected of violating conflict of interest laws, in which they're more accountable to their own interests than the public interest, fired the leader of the Office of Special Counsel, which investigates whistleblower reports from government workers, which again is a method of accountability, the chairwoman of the Merit System Protection Board, which hears appeals to firings and other disciplinary actions against federal officials, the chairwoman of the Federal Labor Relations Authority, which protects federal employee unions from actions taken against them, and the Inspector General of the Office of the Agency for International Development, who days before his firing released a report stating that $489 million in food assistance was about to be wasted because of a freeze and a stop work order. So let's turn to that freeze now, which involves the administration's refusal to spend funds allocated by Congress. Initially, the Office of Management and Budget issued an order to temporarily pause all activities related to obligation or disbursement of all federal assistance. That didn't last long, of course, because of massive opposition and massive confusion. But the administration is still freezing many grants at an agency level, even after courts ordered it to resume disbursement. A president has no authority to refuse to spend funds appropriated by Congress simply because he doesn't like the substance of a program. When he was head of the Office of Legal Counsel, William Rehnquist, later the Chief Justice, wrote that it would be, in his words, extremely difficult to formulate a constitutional theory to justify a refusal by the president to comply with a congressional directive to spend. It may be argued, he continued, that the spending of money is inherently an executive function. But it seems an anomalous proposition that because the executive branch is bound to execute the laws, it is free to decline to execute them. And he explained that this would be especially true in many areas of domestic national policy, whereas he explained the president has no mandate under the Constitution independent from his duty to execute such laws on the subject as Congress chooses to pass. Now, impoundment may sound like a technical issue, but it goes to the heart of accountability. Members of Congress who are accountable to their districts and a president accountable to the people, enacted laws spending money on everything from AIDS prevention in Africa to biomedical research in Alabama to efforts to combat climate change. The constitutional design presupposes that that money will be spent unless and until we have new legislation taking a different course. Elon Musk may have spent a lot of money to support President Trump's re-election efforts, but the fact that he spent that money is not supposed to give him the spending power that the Constitution confers on Congress. When I was working on these remarks, I asked John Jeffries for some advice. I did ask John Jeffries for some advice, and he told me that one example of the move to unaccountability that he thought hadn't gotten enough attention was the proliferation of government by executive order, rather than through legislation. Now, executive orders aren't inherently problematic. A proper executive order is supposed to merely reflect the application of power the president already has to regulate the executive branch. But recent presidents have also been issuing them in areas where the president has not been authorized to act. And as I'll describe in a moment, the current president seems to be doing so without even going through the process that's designed to ensure that he actually does have the power to act in the way he claims. To that point, there's actually, in another meta example, an executive order about executive orders. By President Kennedy, Executive Order 11030, which today actually is embodied in a regulation. It governs the process for issuing executive orders, and among other things, the regulation provides that once OMB has approved an order, it goes to the Attorney General for, in the regulation's words, consideration as to both form and legality. The Attorney General has assigned this function to DOJ's Office of Legal Counsel, where career attorneys review the order for form and legality. My former UVA colleague, Jack Goldsmith, who served as head of the Office of Legal Counsel during the George W. Bush administration, has recently pointed out that there's been a slew of executive orders that seem not to have gone through this process, or at least not to have gone through this process properly. For example, the withdrawal from the Paris Climate Agreement is contrary to prior executive branch views of presidential agreement termination authority. The birthright citizenship order ignores a prior OLC opinion without explaining any reason for the about face. And it directs various federal offices to ignore not just birthright citizenship as promulgated in the 14th Amendment, but also a statute that seems to give birthright citizenship as well. It's impossible to believe that these orders went through the conventional process. So the internal accountability mechanisms of the executive branch seem to have completely broken. Finally, we have an administration that also seems bent on muzzling another of the accountability devices built into the Constitution through the First Amendment, namely a free press. The decision to ban the Associated Press from the Oval Office because it continues to call the Gulf of Mexico by its centuries-old name might seem bizarrely comical if it were not part of a pattern of intimidating and retaliating against news organizations that don't fall in line with the president's agenda. So we have a president doing his best to be unaccountable. He knows that he faces virtually no risk of oversight or impeachment from a Congress whose majority party has been cowed into silence. Whatever his trollish musing, the 22nd Amendment means he no longer has any accountability to the voters. And the Supreme Court has already held that virtually nothing he does in his capacity as president can subject him in his person to future legal sanctions. In 1982, the Supreme Court held in Nixon against Fitzgerald that a president is immune from damages liability for his conduct. And in 2024, the court extended at least presumptive immunity against criminal liability to presidents for any official actions. Moreover, the court held that Congress can't even regulate presidential conduct via statute for a breathtakingly wide swath of conduct that's allegedly within the president's conclusive and preclusive constitutional authority. So the court held that then-President Trump's attempts to use the Justice Department to conduct sham investigations not only couldn't form the basis for a prosecution, it couldn't even be used as evidence with respect to any counts that could be prosecuted. The court has thus essentially given, once again, President Trump a green light to turn the Department of Justice into a vehicle for retribution against his political opponents. And so we come to the court. I've already sketched out many of the ways in which the court has ceased to hold the other branches accountable, paradoxically, even as it aggrandizes itself. In my office at Stanford, I work now behind a desk that was once used by John Hart Ely, one of the leading constitutional theorists of the 20th century. Ely developed what he called a participation-oriented, representation-reinforcing approach to judicial review, one that was designed to enhance rather than to supplant democratic accountability. One of the central functions courts ought to play, according to that theory, is to intervene when, in Ely's words, the ins are choking off the channels of political change to ensure that they will stay in and the outs will stay out. Last term at the Supreme Court, not only did the court foreclose Donald Trump from being prosecuted for the most blatant example in American history of someone trying to stay in when there was other people seeking to come in, but the court's indifference to the attempts of the ins to ensure that they will stay in and the outs will stay out was also on full display in one of the first cases from the term, a case that was much less remarked and noticed on, Alexander against South Carolina State Conference of the NAACP. Alexander was a variety of a Shaw challenge, a cause of action that the Supreme Court invented in the mid-1990s to deal with claims that a particular redistricting plan had relied excessively on race. So the court said that plans could be race-conscious in the sense that they could seek to avoid violating the Voting Rights Act. And of course, politicians always know the demography of their voters, but it couldn't be excessively race-conscious. Now, the South Carolina legislature was redrawing the state's congressional districts, and it wanted to make congressional district number 1 a safer seat for Republicans. It had been a seat that was teetering on the edge as a kind of purple seat. After the 2020 census, the existing District 1 was overpopulated by about 88,000 people, and District 6, which is adjacent to District 1, was underpopulated by about 85,000 people relative to the ideal district size under one person, one vote. So you might think you transfer 80,000 plus people from one district to another, right? And you solve your problem. No. South Carolina moved nearly 200,000 people either into the district or out of the district. And it did so while meticulously keeping the black percentage of the district in the low 20s, right at the point below which it was possible that a Democrat would get elected. The part of Charleston County that the legislature moved out of District 1 was disproportionately black. Of the 11 precincts in District 1 that were that had the largest black population, 10 of them were moved out. A 3-judge district court familiar with South Carolina politics found a Shaw violation, and it also held that the legislature had purposefully tried to minimize black voting strength in Charleston County. The Supreme Court, 6-3, in a decision written by Justice Samuel Alito, reversed. What's particularly striking about Justice Alito's opinion is the way that he treats a partisan desire to keep the existing representatives in office to the disadvantage of a group of minority voters as a perfectly permissible or legitimate government purpose. What the court has done over the past several decades is to move from Davis against Bandemer in 1986, when the court thought that partisan gerrymandering is anti-democratic and is subject to federal judicial review, albeit under a somewhat odd standard, to Veith against Jubileer in 2004, where all 9 justices agreed that there was a constitutional problem here, but they split 4-1 to 2-1 on what the standard should be, to Rucho against Common Cause in 2019, where the court held that that political gerrymandering was troubling, but it should be non-justiciable because there wasn't a manageable standard for figuring out exactly where the line was, to 2019, to Alexander in 2024, where Justice Alito suggests naked partisanship is a defense to a constitutional claim because naked partisanship is consistent with what he calls a presumption of legislative good faith. In short, a legislature acts in good faith when it seeks to entrench representatives in power, regardless whether the electorate still wants them there or not. That decision is unaccountable in just so many ways. These are not the only ways in which the Supreme Court has abandoned holding the other branches accountable. The evisceration of the Bivens remedy for unconstitutional conduct by federal officials, and the suggestion, jumped upon by some lower courts, to eliminate the implied private right of action under Section 2 of the Voting Rights Act are other examples. But I want to turn finally to the other side of the accountability question. Is the Supreme Court an accountable institution? My account of why we have such an unaccountable court may begin from a somewhat unusual place. Think about the court that decided Brown against Board of Education, the case that I think more than anything else endowed the court with the capital it has with the American people. That court numbered among its members former senators, representatives, and state legislators, a former governor who actually had been nominated by both political parties when he ran for re-election, and a former mayor, former cabinet members. These were men who had careers of accountability behind them by the time they became judges. The current court, by contrast, has not a single member who has ever sought, as far as I can tell, let alone served in significant elected public office. 6 of the 9 justices had, as their formative early professional experience, clerking on the court. Now, those of us who had the privilege to clerk there, you wouldn't give that up. But it does create a kind of romanticized view of the court that I think does not hold you in good stead as you get older and you spend your whole life trying to get back there. The Chief Justice has affirmed, not me. I became unnominatable and unconfirmable within like 2 years of graduating from law school. So, the Chief Justice has affirmatively celebrated the narrower career path in which being a Court of Appeals judge is the way to become a Supreme Court justice, and 8 of the 9 justices, that's how they got there. And that creates a group of people who are eager to hold everyone else to account, but maybe resistant to any kind of accountability for themselves. The fact that they can't even agree to a mandatory recusal policy for cases in which they have a conflict of interest is only the most clear-cut example of this resistance. Judicial independence is, of course, a critical feature of any democratic polity. But while there are some things from which judges must, of course, be free, freedom from physical threats and freedom from political pressure to decide particular cases, particular ways are only 2 of the most obvious, judges must remain accountable in a variety of other ways, or else democracy is lost. So what is to be done given this firestorm of unaccountability? In 1944, Judge Learned Hand gave a speech in Central Park on I Am an American Day, when more than 1 million people gathered to watch 150,000 newly naturalized citizens take the Pledge of Allegiance. Near the beginning of his speech, which has come to be known as the Spirit of Liberty, he wondered whether, in his words, we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes, he said. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. Now, I don't think he's right about that second part, but I do think he's right about the first. What is this liberty, Judge Hand asked, which must lie in the hearts of men and women? It is not, he said, the ruthless, the unbridled will. It is not freedom to do as one likes. That is a denial of liberty and leads straight to its overthrow. A society in which men recognize no check upon their freedom soon becomes a society where freedom is the possession of only a savage few, as we have learned to our sorrow. Part of what Judge Hand was telling his audience, and I think us, is that ultimately it's up to the people to hold the government accountable. And he ended his speech by invoking, in his words, the spirit of an America which has never been, and which may never be, nay, which never will be, except as the conscience and courage of Americans create it, before leading the audience in the pledge. So I end by asking you, to what and to whom should we be accountable in our lives as lawyers? And just as important, what will we do to hold the government accountable? I don't think this is an easy question. This past fall, I taught a reading group for first years at Stanford on exit, voice, and loyalty. in which, among other things, we read C.S. Lewis's 1944 lecture, The Inner Ring, and Hannah Arendt's 1964 essay, Personal Responsibility Under Dictatorship. What concerned Lewis and Arendt was the temptation for very bright people to enter organizations and lose their moral compass as they start to justify the actions of the organization they've entered. Lewis suggests that the desire to be part of the inner circle, to be an insider, is a powerful human motion, and he warns that unless you take measures to prevent this, that desire is going to become one of the chief motives of your life from the first day you enter your profession until the day when you're too old to care. So what's the danger in that? Well, he says that the risk is that you're going to be gradually drawn into doing things that are quite wrong out of a desire to fit in. Instead, you should seek out colleagues with integrity and ally yourself with them. Arendt, who was writing about how public servants in Nazi Germany responded to the regime, focuses first on the people who stayed involved, but who argued that their continued participation at least prevented the people in power from doing things that were worse. She's not persuaded by that because she believes that the weakness of that argument is that people who choose the lesser evil very soon forget that they chose evil at all. And she makes the point that all organizations, and this would be true of private companies as well as governments, require the obedience of subordinates in order to function. Thus, to obey the leaders is ultimately to support them, and you're not just a cog in that machine. So what leads some people to withdraw their support and to quit? Well, Arendt says that the people who left focused on the extent to which they would still be able to live in peace with themselves after having committed certain deeds. They left, in her words, not because the world would inevitably then be changed for the better, but simply because only on this condition could they go on living with themselves at all. So here we are in Kaplan Pavilion, named after, as Leslie told you, a graduate of the law school who had a deep commitment to public service. Serving in the government is a wonderful opportunity. I've served in the Department of Justice twice, and each time it was the honor of a professional lifetime. I got to work with talented, committed career civil servants to try to improve the lives of people in the United States. But there are risks in those jobs as well. You may be asked to support policies or make arguments that you think can't be squared with the oath you took to support the Constitution. The lesson is to learn again how to do something that you knew well when you were 2 years old, and I'm sure your parents will remember if you ask them. The two things are saying no and I won't. In recent weeks, lawyers like Danielle Sassoon and Hagan Scotton in the Southern District and career officials throughout the federal government have shown that kind of courage and integrity. They've held themselves accountable to their oaths, and we should all hope to do the same. And we should hold each other accountable as well. Thank you very much.